Welcome, everybody, and thank you for joining us here today for Patent Masters 2022. This is our second annual Patent Masters event. Virtual again. It's hard to believe that we're virtual still, although I think there is an end in sight to when we'll be doing virtual programming here. Hopefully by the spring of 2022, we'll be back to live programming. It looks like there is a light at the end of the tunnel. Scott, happy to have you here with us. Scott McKeown is our co-chair. He is a partner at Ropes and Gray. He is the author of the award-winning patentsPostgrant.com. And if you need to know anything about patents in the post-grant world and you're not familiar with his writing, you really need to become familiar. Scott, thanks for joining us here today.
Thanks for having me in the bunker here. So looking forward to 4 days of nothing but PTAB discussions. So
Yeah, very good. So okay, so now Renee's saying the sound is very low, but we can't go too high, otherwise it's going to start to pinch here. So hopefully you can turn up the volume, Renee, because I'm starting to hear some feedback already. So in any event, Scott, what is it that you would like people to have in mind as we start the conversation here today about all things PTAB related?
I think that we're going to cover not just nuts and bolts or practice tips, but insight into where we're headed, policy, the new director, pending legislation. All of this kind of swirls around and evolves into practice. And that's what your attorneys, or if you're a patent owner or a patent challenger, these are the things that you need to anticipate. And it seems every year there's a lot going on in terms of whether there's a Supreme Court case pending, or in this instance, we're looking forward to a new director here on the heels of the past administration that did a number of things, in terms of adjusting the practice at the PTAB. And so, what we're looking at in some of the segments today are, well, what might happen with the new director in terms of, potentially rolling back some of those initiatives of the past administration, and what that pending, or shouldn't say pending legislation, proposed legislation that, I expect that will be pushed here in the months ahead. So there, it's really a look forward into not only past, what stakeholders have been grappling with at the PTAB, but where we're headed in terms of, like I said, new legislation, new leadership, and new practice trends. So we'll cover all of that in addition to a little bit of the nuts and bolts. But this is really meant to be, sort of a holistic program of, just a big picture view. And in some instances, we'll get down into the weeds. But certainly, if you're watching, feel free to email Gene. I'm not sure how the questions are coming in, Gene, but we'll certainly drive the program in the direction that the audience is interested in.
Yeah, we have. I'll be monitoring the chat as we're going along, so feel free to send in questions via the chat, and I'll be moderating some of the panels. You all know that I'm not the PTAB expert. I may be a bit of the policy expert, and we have all kinds of folks lined up to talk about the nitty-gritty of what is actually going on at the PTAB for those people who practice in this area, as well as policy experts. We're going to hear coming up here from Senator Tillis, a brief opening remark here in a moment, and then our keynote is Andrei Iancu, who I talked to for about an hour or so, and we're going to play that piece by piece over the 4 days as it relates to the topic of the day. But Scott, in your view, what are the big policy? I know the last day is when we're gonna really get into sort of looking at the policy, but today we're going to talk about the PTAB present, PTAB tomorrow, and but what do you see facing the PTAB 10 years in now?
I think a lot of what we'll talk about are, as I mentioned, the past administrations seem to be attempting to recalibrate the system more to help patent owners and potentially we're looking at new leadership coming in that may roll back some of those changes, and some of the more controversial changes over the past couple of years, discretionary practice, this interrelationship with some of the faster jurisdictions in the country, Western District of Texas. Where does the PTAB fit in to that whole equation? And should the agency be making what are essentially policy determinations on whether or not to move forward based upon what's happening in litigation? And, we see at least some effort from Senator Leahy to say, hey, wait a minute, we need to recalibrate the statutes in order to uncalibrate the recalibration that was done by some of the administration, and maybe at least from his perspective and the supporters of that legislative initiative, that there needs to be some kind of rebalancing, and we've seen over the past couple of years in dealing with this discretionary practice, sort of other practices that have evolved from that in response to what the agency was doing, stipulating about what prior art that you'll be using in a given litigation, and whether or not all of that stuff that has been happening since the AIA passed is something the authors of that bill really want to happen, and maybe we're moving more towards more of a bifurcated system where you look at some of the proposals in that bill to put a heavy thumb on the scales there in terms of staying litigation pending a PTAB challenge. So that's what we're looking for, I think, in the program. That's what we're looking at in terms of potential upcoming events, just again with everything that's going on with the new director and the movement in Congress, not only to address the PTAB, but to address Western District of Texas practices, and to alert the Judicial Conference about what was going on down there, and then to send letters to the PTO itself and say, hey, wait a minute, these trial dates aren't really realistic. So there's just a lot of effort, and there's a lot of chefs in the kitchen right now trying to pull the AIA and pull the PTAB practice in different directions, and we hope to hit on all of those perspectives in addition to just the overall practice and how things are working.
Yeah. One question I want to ask you, I probably should have told you I was going to tee this up for you, but I found it amusing after the bill came out, and you were quoted in some articles, and it became clear that you had given some suggestions to Leahy's staffers, and I know how that goes. The people in DC know how that goes. I've given some suggestions at times, and a lot of times those suggestions fall on deaf ears. Sometimes they're warmly received, and you kind of got a little bit pilloried by some people on the blogosphere who don't necessarily understand how it works here in town. Can you just, and I'm happy to give my 2 cents, but how did that come about? And can you just shed some light for people who don't really understand? Because when you're here in town and you're accessible to people in Senate or in the House who are concerned about an issue, they do reach out.
Mm-hmm. And that's what it really is. Over the summer, leading up to this legislative effort, you get involved with conversations with stakeholders, and you do get the calls to say, hey, we're thinking about X, Y, and Z. Is that really the problem that I'm hearing in terms of is this really something that stakeholders are interested in? Is this really a challenge? Where did the past effort not really dot an I or cross a T? And so they're more of those conversations. I mean, the lobbyists are who's
right.
who's being listened to. I'm just the the wonk that they call up to say, well, if we were going to change this, what would we be looking at? What would we do? What statute really comes into play here? What aspect of the statute? So it tends to be more of that. I mean, no one cares what I think, in terms of.
Well, I don't know that that's true. I mean, what I'll say, let me break it here, because I think what happens is, you're right. The lobbyists they're very well paid, and not to say anything bad about lobbyists. I mean, they're very well paid for a reason, because after you have heard them give their spiel, it's hard not to agree with whatever side that they're presenting. They're extremely well trained lawyers. They're very persuasive. I get those calls a lot of times thinking, and people are saying, am I really being told the right thing? It's sort of like a sanity check, a reality check.
Right, and that's what it tends to be more often than not, and the discussions I get involved with are the ones all the way down in the weeds. And what about this joinder practice? Does that make sense? And the winner estoppel, and if you win at the PTAB, why shouldn't you be able to argue that prior art later? Does it make sense for there to be winner estoppel? Were we just too generic in the way we worded that statute? So that's the kinds of things that I get involved in. Whether IPR should have 112 or some of these big picture issues. The lobbyists are driving that conversation.
Oh, yeah.
It's you got biopharma saying no, this will be the worst thing that ever happened. Then you have big tech saying, well, that would be helpful because we have these situations where we challenge patents and everyone throws up their hands and states, well, we don't know what that claim term means, so everybody go home. And that's not an efficient way to run the system. So you've got the tug of war on the big policy issues, and then once you select what you want to address in your proposal, then it's, well, how are we going to do it? And that's sort of where I sometimes get called in.
Yeah. Well, good. Okay, so what we're going to do right now is I am going to we're going to pivot to hear the opening remarks from Senator Tillis, and then we're going to listen to the beginning of the conversation with Andrei Iancu. Then we'll come back and get Scott's instant thoughts and analysis on that, and then we'll be on to our first panel of the day. So just give me 1 minute here. Kasha, if you could switch over to the laptop feed.
Hello, I'm Thom Tillis, Senator from the great state of North Carolina and ranking member of the Intellectual Property Subcommittee. Thank you to the co-chairs of this event, Gene and Scott, for inviting me. I'm grateful for the hard work and dedication you put into making IP Watchdog's PTAB Masters program happen. I also want to thank the participants. It is important to take the time to learn how to improve the legal profession, to develop new skills, and learn from each other. By doing so, you're not only improving our abilities, but the entire patent system. The Patent Trials and Appeals Board serves as a critical role in our nation's intellectual property system. Patent decisions are reviewed by experts with background knowledge in technology. At its best, it can correct mistakes made in the examination process without the expense and risk of federal litigation and jury trials. There's no question that the PTAB inter partes proceedings established under the American Invents Act dramatically altered the patent system. On one hand, it eliminated the delays caused by inter partes re-examination. On the other hand, the dramatic increase in IPR petitions earned it the nickname of Death Squad for patents. The PTAB was rightly known as the place where big companies could game the system, engage in strategic and efficient infringement, and destroy the patent rights of small businesses and independent inventors. Nothing better demonstrates this type of gamesmanship than recent petitions filed by Open Sky Industries. Director Iancu made necessary and critical reforms to help bring balance to the patent system. Thanks to his visionary leadership, the PTAB now protects small businesses and independent inventors and has finally achieved the balance Congress intended when we passed the America Invents Act. During Ms. Vidal's nomination process, I asked tough questions on her views regarding these reforms and sought a simple yes or no commitment on whether she would continue them. I've made my position clear. Any nominee will need to commit to continuing Director Iancu's positive reforms to receive my vote, and I'm happy to say that I've received such a commitment. I believe Ms. Vidal will be the leader we need to succeed Director Iancu. She will work tirelessly to ensure all inventors get a fair shake before the USPTO. Yet we still need to ask ourselves whether we believe these initiatives and reforms have long-term merit and value. If so, I believe Congress needs to think about codifying these PTAB reforms so that no future director can undo the progress that's been made. The Arthrex decision also represents the right opportunity to consider how best to restructure the PTAB to ensure it fulfills its essential function in validating low-quality patents, which should have never been issued, and is a fair, equitable, and impartial forum for all inventors. The PTAB should not be a forum for large companies to use serial and parallel AIA petitions to bankrupt small inventors. There are many other questions that Congress, the USPTO, and others must continually address and answer. Do patent owners still have access to effective remedies to stop infringement from bad actors, including corporate actors who make concise economic choice to infringe? Are measures needed to prevent some non-practicing entities from hoarding patents and using them in ways that ultimately undermine innovation? Does our patent system adequately and accurately reflect our citizenship? Is it sufficiently transparent, especially with regard to patent ownership? That's why I'm glad you're here today. If you have ideas about how to improve PTAB or the broader ecosystem, we welcome your input. I hope this program helps each of you find ways to work better and to help improve our intellectual property system. Working together, I'm confident that we can keep the American dream alive and ensure the United States remains the world's leading innovation economy. Thank you again for having me today.
Hello, everyone. This is Gene Quinn. Thank you for joining us for this segment of our program. I'm honored today to be joined by Andrei Iancu, who is the most immediate past director of the Patent and Trademark Office, and he is a partner at Arel and Manella, and he's got some other things going on in DC at a think tank, and he's back to litigating, and he is one of the leading voices on all things in the patents space, and in particular now, Andrei, you're getting into national security policy. I see with your the think tank, so maybe we can talk a little bit about that as well. But I appreciate you being here to talk to us today about the PTAB.
Great. Well, good to be with you again, Gene. Always a pleasure and an honor, and happy to talk about all of those subjects.
And maybe we should just let's just start with right off the bat. What are you doing now, specifically with Arel and Manella and with the think tank, and just give people an update?
Well, sure. So, I left the USPTO a year ago or so, and since then I've come back to my law firm at Arel and Manella, where I am an IP litigator as in the past. I'm also doing other things there nowadays, including some policy work and advice to clients with respect to IP policy and IP strategy overall. In addition to that, as you've mentioned, I am at CSIS, which is a bipartisan think tank here in Washington, D.C. As part of that, we continue to look at IP policy from all aspects. But CSIS historically comes from the national security perspective, and in addition to our traditional ways of looking at IP, which primarily relates to the economy and jobs and innovation and so on, we are applying a national security lens to that as well.
Yeah, and I don't know which one of our programs is going to be appropriate, and maybe it'll just be the big annual program, but I want to get a little bit more involved in that, because has it struck you as odd that hasn't become much more of an important aspect of the IP realm? I mean, I look around at the supply chains, and even before the supply chains became a part of almost every news broadcast, we knew that we were leveraging the manufacturing overseas, and it just was leaving America, and that really leaves America quite vulnerable. Has it surprised you that this has not resonated more already?
It has, and it's not a coincidence that after the PTO I went to CSIS because I wanted to make this connection. But it is indeed surprising that our national policymakers have not made this connection yet. Some are beginning to do so now, but still we're way behind, Gene. The critical connection between innovation and our national security is not at the top of mind for most of our policymakers. And if you think about it, to some extent, we've gotten as a nation complacent. In the 20th century, we've led in virtually all areas of technology. Beginning at the 20th century with automation and auto manufacturing, Henry Ford and the like, to the aerospace industry, beginning with our favorite, mutually joined favorite inventors, the Wright brothers, through the computing age, through the internet age, biotechnology and the like. We to some extent have gotten used to be the technological leaders. 21st century is not the same. And frankly, it's not the same by a long stretch. All the countries in the world, or I should take that back, many countries in the world have figured this out. And from big to small and everyone in between, a lot of companies are now competing with us for that technological advantage. And we're feeling it. And I've spoken quite a bit about that when I was at the PTO. I've spoken a lot about it in the past year since I've left the PTO. Right now, Americans are feeling it every day. The supply chains are a very good example that you've referenced. There's a chip shortage in the United States. We barely manufacture any advanced semiconductor chips here in the United States, and we invented the semiconductor. We have a Silicon Valley, yet we barely manufacture any. The vast majority are manufactured in China and Taiwan and elsewhere in the world. And here we are, we don't have enough chips for anything, for automobiles, refrigerators, pacemakers, and lots of other things.
You know, it's funny, if Silicon Valley was a trademark, it would probably get rejected as being misdescriptive. There's not a lot of silicon in the valley anymore. I mean, it's all over the place, you know, it's everywhere except the U.S.
And I don't think it's a coincidence, you know. It goes hand in hand with the systematic weakening of our intellectual property system over the years and last couple of decades. I'll give you another example that's apropos to the immediate times when we're speaking right now. We are 2 years into the COVID pandemic, and there's a shortage of test kits. It's not like there's a surprise that we needed test kits. There's a shortage of it now, and there's long lines in many cities in the country. Now, there are many reasons for that. Some of it is the lack of preparation in the administration and the like. But do people actually think that it's a coincidence that there are not more companies inventing and making new types of tests? You know, even if under the best case scenario, there are only a couple, 2, 3 brands or types of take-home tests for COVID. Where's all the competition? Where are all the people clamoring to come up with a new thing, a new way of making tests? As I said, there are lots of reasons for this, but the lack of patent protection for diagnostic technologies is one of those reasons. And it's, you know, it's folks like us who are in the middle of the IP space that know that there is basically no patent protection since the Mayo case on diagnostics. And is it a surprise that private industry is not investing enough in creating new diagnostics as a result? So everything we're experiencing has some connection to the state of intellectual property, and the United States is leaving itself extremely vulnerable if we don't attend to it. Let me give you one more example.
Sure.
Telecommunications, 5G, which, by the way, we're now on the cusp of 6G, for those of us who are still trying to get used to 5G. Where, you know, we're left behind there as well. Where are all the American companies who are making 5G technology? We're being way outpaced by China and others. And this is happening in new technology area after technology area. And if we're not careful, we're going to wake up a few years from now and really wonder, gee, what has happened to our technological leadership?
Yeah, you know, and there's so much that's there. I've written a lot about the medical diagnostics, and it really is no no surprise that nobody's investing in medical diagnostics, and to the extent that they are, it's all trade secrets, and it's about the data. It's not about the actual science or test, and it's been frustrating, and you know, a lot of people will point to the PTAB, you know, which is the substance of this particular program, as playing an important role in the decline of the U.S. patent system, because you go out and you hire, not you in particular, but we as a nation, you hire about 300, you know, 250 probably, and it's not fair to say we hired them, and we had probably about 70 or 80, so we probably wound up hiring about 190 to 200 or so new PTAB judges, and you tell these judges, look, you're being hired because there's this quote-unquote bad patent problem. You know, when you are a hammer, the world looks like a nail, and you know, we got an awful lot of bad patents, not surprisingly, because that's what people were looking for. Is the PTAB, do you think, where it should be 10 years in? Are there more reforms to be done? Is it maturing at the pace that you expected that it would? Are we getting to some equilibrium point? What do you think?
Look, I think we are getting to some equilibrium point, but unfortunately there are always, with respect to the PTAB at least, there have been and continue to be pressures on the agency and on the PTAB itself to keep changing it and bring it out of equilibrium. As you know, when I first came in 4 years ago, I thought, and I said publicly, that the PTAB is out of balance, and there are many reasons for it, and immediately we set upon making a number of reforms, beginning with the claim construction standard and making it the same as in this report, and many other things, obviously, as you know. But there's pressure right now to roll some of that back. So in my view, obviously, I was in favor of those changes because I thought it brings the system back into more balance. I think it's definitely more balanced now than it was 4 years ago. Pushing it back, would make it less balanced. There's so many issues with that statute that created the PTAB. And I really think that the system would benefit if we're going to have the PTAB and if we're going to have post-grant proceedings, which is the case now since the AIA in 2012. I really think the system would benefit from a codification of a number of those changes that we have made so that it does become more stable and it is not susceptible to the vicissitudes of new and varying leadership or new and varying pressures from Congress and the like.
Okay, so we're back. Scott, your instant analysis.
I think it's interesting to see Tillis call out a particular petitioner, the Open Sky group, and some of the others that have formed recently to challenge the some of these big money verdicts, VLSI in this case. And I think that's telling in terms of where the agency may go. You know, when you get senators referencing specific petitioners, that's a strong indicator that maybe you should be doing something about that practice. And it's interesting to hear Tillis be in favor of some kind of incremental change that would tamp that practice down, and then consider that in view of the practice that sort of created it, which is the 314A discretionary practice. When Intel, in this case, challenged those VLSI patents, they were told that, well, you've got a trial date coming up and we're going to use our discretion to not move forward on that challenge. And then as a result of that, you've got this incredibly bad look of, essentially, well, I'll just call it a profiteer, incorporating and challenging a patent for the sole purpose of, well, it's got a big money verdict. If I can get an IPR going and maybe, Intel can join, I'll get a quick payout because the patent owner doesn't want anything to do with that. So, and then to hear, former Director Iancu talk about the semiconductor industry. Yeah, I mean, it's an issue. It's an issue of national security. And as a patent owner, you may think, well, that's great that, VLSI gets their day in court and that the PTAB didn't interfere. But I think as an American, you sit back and you say, well, wait a minute. Let's assume, and we don't know for sure, that this patent is vulnerable. You just taxed in a very important industry to the tune of $2 billion. So is that the way the system should work? So, there's a lot going on here. As I said, it seems as though Tillis is in favor of maintaining discretionary practices, but sort of tweaking them to get rid of these open sky folks. And so, there's no binary answer here in terms of should we have it, should we not. I mean, Leahy certainly believes that, but there are clearly bad actors out there, and I'll call them bad actors because I don't think our patent system wants the optics of, well, once you enforce your patent and get this big money verdict, everyone's going to come out of the woodwork and attack you in an important industry like semiconductors.
Yeah. It was interesting to hear him talk about that. I mean, he's very engaged. He knows what's going on. Or he's very well briefed. I think there's a little bit of both. He's obviously very well briefed, and we know who's briefing him on his staff, and they are very engaged in intellectual property. And he himself is very engaged in intellectual property based on his background, having worked for IBM, and he gets it and he cares. And it's obvious. When he was ranking member, they were extremely busy, and he had a very good working relationship with Senator Coons, and that continues with Senator Leahy, it seems. So they're paying attention. At least in the Senate, they're very closely paying attention.
Yeah. And it's, part of this too is when you hear terms like big tech, and even I use it and I sort of cringe sometimes, is it's this polarization of the debate like you see in politics everywhere. You're either on the side of the bully or, you're on the side of David, not Goliath. And I don't think that's the way to view it. Big tech provides tons of engineering jobs in this country, and they're important to this country, just as important as independent inventors are. And, we can't just dismiss everything as, well, it's the big guys taking everything. And, that's a bit melodramatic. There's certainly important innovations that come from small independent inventors, but, and this is just the world according to Scott. It's we have to have balance for everyone, and it can't be one extreme over the other, and that's part of the problem we see here in DC all the time, and we saw it with 101, right?
Yeah.
Give me my way or you're wrong. No, give me my. And so nothing at the end of the day happens, and then you have administrative agencies coming in like Director Iancu and saying, well, this is out of balance. I need to fix it. And you create these discretionary practices that may be an overreach and into the province of the legislature, and deciding, do you want an APJ deciding a $2 billion issue by saying, I'm not going to decide it, right? So, when they make those decisions, you'll hear those that hate the PTAB cheer it. But, if they make a merits-based decision and cancel claims, then they're evil and, they're fake judges and all that kind of stuff. So, you can't have it both ways. And we need to come to some kind of sensible balance over the next, 12 months, hopefully, with all what's going on right now.
Wow, that's a cheery view of the world. 12 months, we're going to figure this all out.
I'm putting it all on the shoulders of the new director, and, I'm sure she'll figure it all out.
Yeah, good. Okay, well, great. Well, so we're going to pivot right into the next panel, and the next panel is going to pick up on this theme of talking about what's going on with the PTAB today, and it's actually the title of the panel is the